Hello, I'm Scott Johnson, General Counsel of Louisiana REALTORS, and this is a video recap of the topics discussed during Week 2 of Risk Management Month. Last week we discussed agents' duty of confidentiality towards former clients, procuring cause, RESPA and how it affects home service contracts. We discussed the as-is waiver of warranty clause in the purchase agreement, and we discussed short sale disclosure issues. Let's talk about some of those topics now. On Monday, we talked about the duty of confidentiality to former clients. In the case of a listing agreement that's expired, an agent who no longer represents the seller may sometimes represent a buyer interested in that same property. It's important to remember that the agent's duty of confidentiality towards the seller survives that relationship. Otherwise, there is no duty towards a former client. But in negotiations with a former seller, the agent now representing the buyer must protect the seller's confidential information, and it's a good idea when ending a relationship with a client to discuss how this may play out in the future. On Tuesday, we talked about procuring cause, which is one of the most popular topics at our legal hotline and probably one of the most frustrating topics for agents. Procuring cause is the issue used to determine which broker is entitled to cooperative compensation in a transaction. When there's a dispute between brokers on compensation, that issue will ultimately be determined by a panel of arbitrators. Many brokers want to know in advance whether they will be determined as procuring cause, but that's impossible to predict. The procuring cause analysis weighs so many factors, and no one factor determines who's entitled to that compensation. For example, it's not always the agent who showed the property first who will receive the compensation, nor is it necessarily the agent who submitted the contract. Ultimately, all the conduct of the agents involved will be weighed by the panel, and they will make the determination of who is procuring cause. For brokers who are interested in having a little more control in resolving their issue, mediation is a great forum where the parties shape their own resolution rather than relying on a panel for that decision. On Wednesday, we talked about the new HUD interpretive ruling on agents who receive compensation for selling home service contracts. One thing we learned from the new interpretive rule is that brokers and agents can receive compensation from home service contract companies. However, that compensation cannot be for a mere referral of business. Instead, the agent or broker must do work in exchange for the compensation received. It would appear that filling out an application on behalf of the client to be submitted to the home service contract company would not be enough to satisfy HUD under RESPA. Instead, some of the examples that HUD gives of acceptable work in exchange for compensation would be taking an inventory of the items covered in the home, taking down the serial numbers, or even photographing those items. These are just some of the examples of compensable work under HUD's new interpretive ruling. For further information, check our online resources to determine whether you're in compliance with RESPA as you work with home service contract companies. On Thursday, we talked about the as-is waiver of warranty clause of the purchase agreement. This clause warrants careful review with your clients so that they can make an informed decision about that section of the contract. This clause doesn't mean that the seller won't be asked to make repairs leading up to the actual closing. Instead, this clause deals with post-sale rights and not pre-closing responsibilities. The inspection period actually addresses how the parties will interact and whether the seller might be asked to make pre-sale repairs to the property. After the sale, however, the waiver of the warranty by the buyer does protect the seller in that the buyer can no longer ask for a rescission of the sale or a reduction in the selling price if they discover a hidden defect in the property. That, of course, does not include defects fraudulently or knowingly hidden by the seller. And on Friday, we discussed short sales and the disclosure issues associated with those transactions. Generally speaking, the likelihood of a pending short sale is confidential information of the sellers that can't be disclosed without the client's consent. However, many MLSs have adopted rules that require disclosure of a pending short sale for all listings in the MLS. In that case, an agent has to discuss this requirement with their client and obtain their consent before they list the property. Even if it's not required to disclose that within the MLS rules, agents should discuss with their clients whether it's in their best interest to disclose a likely short sale at the beginning of the transaction. Short sale transactions have many unexpected delays and extra hurdles, and many buyers are often disappointed when they learn after the fact that these delays are going to come up. A seller may not lose any bargaining position and gain the trust of the buyer by disclosing a potential short sale up front. That may also allow the parties to better work together with the bank to come up with a transaction that suits everybody's needs. Agents who are considering handling short sale transactions should educate themselves about the complications of that process, and LARealtors.org and Realtor.org are two excellent resources for that information. Please stay tuned for more helpful topics during Risk Management Month, and thanks for joining us today.